Canada. A land of endless opportunities, extraordinary beauty, and prosperity. A place that is known for kindness, benevolence, and generosity. A place that is built on courage, integrity, and truth. Or so it appears. Yet, something doesn't feel right. Can you feel it? The underlying sense of unease and discomfort. That feeling when you know you're being deceived, and you're wondering, how big of a lie could it be? For how long have we been lied to? How much of all this is possibly a show? A well-played theatrical performance? Or maybe it's all an illusion? Is it time to see what is behind the curtain? Is it time to resist the control system? To unplug from the matrix and switch it off? In 1759, at the Battle of the Plains of Abraham, Great Britain defeated France and renamed the colony to the province of Quebec. In 1776, the 13 British colonies to the south declared independence from Great Britain and formed the United States of America. In 1791, the Constitutional Act divided the province of Quebec into the provinces of Lower Canada and Upper Canada. In 1840, the Act of Union merged the colonies of Upper Canada and Lower Canada into the province of Canada. In 1864, at the Quebec Conference, delegates from each colony discussed the desire to form a federal union, while each province would retain its independence and autonomy under the umbrella of a constitutional monarchy. From 1861 to 1865, during the American Civil War between the Union, the North, and the Confederacy, the South, Great Britain built warships for the Confederacy, armed with British weapons. Many merchant ships of the Union were destroyed by the Confederate Army in Great Britain. When Lincoln won the war, he sought claims from Great Britain, but Great Britain refused. The Union even threatened to declare war and annex British North America in 1866. In 1866, John A. Macdonald, chairman of the delegates from the colonies, participated in finalizing the Kingdom of Canada Bill at the London Conference to draft the BNA Act. Great Britain had a dilemma: risk a possible war with the United States of America, pay reparations for the sinking of the Union's ships, grant the colonies in Canada self-governance. Queen Victoria needed a clever solution. Lord Thring's brilliant scheme: keep the Canadian colonies and make them pay the reparations to the United States of America through taxation, while deceiving the colonies into thinking that they govern themselves. On March 29, 1867, the British North America Act received royal assent, meaning it was formally approved by the court in Chancery. It went into effect on July 1, 1867, and created a united colony known as the Dominion of Canada. Until 1982, July 1st was celebrated as Dominion Day. Since 1982, July 1st has been celebrated as Canada Day, when the BNA Act was renamed the Constitution Act. Let us take a closer look at the original BNA Act 1867. This is the intended preamble. And it states, by reason of the request of the colonies for federal government, it is expedient therefore that they have laws and regulations to guide them. This is the modified preamble. And it states, whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to be federally united into one dominion under the Crown. The 1889 Interpretation Act defined a British possession to be any part of a dominion, and it defined the term colony to be any part of a dominion. The Dominion of Canada was clearly a colony of Great Britain and not an independent country. The colony did not confederate in 1867. The BNA Act was not brought back to Canada for the United Colony to sign and ratify. The original BNA Act is located in the United Kingdom and has always been the property of the United Kingdom and not Canada. Section 2 of the BNA Act 1867 declares that the provisions of this act extend to the heirs and successors of the kings and queens of Great Britain. Section 109 of the BNA Act 1867 states that all lands, minerals, and royalties belonging to the several provinces of Canada, Nova Scotia, and New Brunswick at the Union shall belong to the several provinces of Ontario, Quebec, Nova Scotia, and New Brunswick. All natural resources belong to the various colonies, with exceptions as per Section 109. More land was to be added to the Dominion of Canada through use. If the Dominion could use the land, then they could claim the land. In 1868, through the Rupert's Land Act, use of land was purchased from the Hudson's Bay Company. In 1870, through the Manitoba Act. And in 1871, through the British Columbia Terms of Union. In 1871, the Treaty of Washington was concluded. It settled the claims between the United Kingdom and the United States of America, even though the United Kingdom never admitted any wrongdoing. However, it is interesting to see whose names also show up. Sir John Alexander Macdonald, Knight Commander of the Most Honorable Order of the Bath, a member of Her Majesty's Privy Council for Canada, and Minister of Justice and Attorney General of Her Majesty's Dominion of Canada, and Montague Bernard. The Privy Council is a formal body of advisors to the monarch of the United Kingdom, in this case, Queen Victoria, meaning John A. Macdonald represented Great Britain. In 1867, Macdonald was appointed, and not voted in, as Prime Minister by the Governor-General at the time, Lord Monck. In 1854, Macdonald, a Freemason since 1844, became a member of the Order of the Masonic Knights Templar. Macdonald got engaged to the much younger Susan Agnes Bernard, cousin of Montague Bernard, who worked with British royalty, in London in December of 1866. They married in February of 1867, 1 month before the BNA Act was signed. John A. Macdonald was the one who helped Queen Victoria achieve her grand scheme of deceiving the colonists into thinking they were now self-governed and had confederated. He received generous titles, appointments in the British monarchy, and a much younger second wife in addition to his annual salary of $5,000 equivalent to $125,000 today, in return for a betrayal of the colonists. In the Treaty of Washington, 1871, John A. Macdonald agreed to give the San Juan Islands and Point Roberts to the United States of America, in addition to granting equal rights to the fisheries for 10 years, because he was representing Great Britain and not the Dominion of Canada. How can he be called the father of Confederation and a hero by some when a confederation was never achieved, and when he in fact betrayed the colonists? By means of the Letters Patent Revocation Act, 1878, the British monarchy instituted the office of Governor-General of the Dominion on a permanent basis. The most important part is found in Section 9 of the Act. The British monarchy declared full power and authority through letters patent, including their heirs and successors. Letters patent are an official declaration used to grant patent rights by the Crown and Chancery to officially grant titles and office to people, or make other declarations. With this Letters Patent Revocation Act, Section 2 of the BNA Act, 1867, was now redundant. Recall, the provisions of this act extend to the heirs and successors of the kings and queens of Great Britain. On June 19, 1893, the Statute Law Revision Act was passed. With it, Queen Victoria explicitly repealed Section 2 of the BNA Act, 1867. This Statute Law Revision Act, 1893, was never repealed after it was passed, and Section 2 of the BNA Act, 1867, was never reenacted. Queen Victoria died on January 22, 1901, from a brain hemorrhage while residing at Osborne House. Interestingly, during the same time as Guglielmo Marconi fired up a very powerful radio wave antenna just 12 miles away. With her death, the BNA Act died as well, due to the repeal of Section 2. Did this remove the British monarchy? No, because of the Letters Patent Revocation Act, 1878. Did this end the Dominion of Canada? No, because of the Letters Patent Revocation Act, 1878, and the Interpretation Act, 1889. Recall the definition of the term colony. The Dominion of Canada and the British monarchy carried on under Edward VII. More land was added via use to the Dominion of Canada between 1898 and 1905. In 1898, through the Yukon Territory Act. In 1905, through the Alberta Act. And in 1905, through the Saskatchewan Act. Who owned the land of the Dominion of Canada? Did the land of the Dominion of Canada belong to the monarch? No. the Crown and Chancery held the title to all British lands, including the Dominion of Canada. The Crown and Chancery is the Department of Lands of Britain. It was established by the Privy Council. The Crown is a corporation sole. It represents the state in all its aspects. It can be used to refer to the office of the monarch or the monarchy as institutions. It can be used to refer to the rule of law or the functions of executive, legislative, and judicial governance. This is why all government and public land was called Crown land until it was granted by means of a Crown grant, also referred to as a land patent. The monarch was just a figurehead. The king or queen was not a sovereign any longer because they did not own the land. The governor-general had more authority. He was also a corporation sole, given the sole government of the colony, with the assistance of members of the Privy Council and appointed by the Crown and Chancery. What is the difference between a monarch and a sovereign? Authority of government originates in the title to land. A king or queen is a sovereign when he or she has absolute authority over the land, and thus absolute power. A king or queen becomes a monarch when he or she does not have absolute authority over the land. The king or queen alone has no power. The title to all British lands was held by the Crown and Chancery and not by the king or queen. All government and public land was called Crown land. The Governor-General had sole authority to govern Canada as a corporation sole with the advice of the Privy Council. He was appointed by the commission created in 1878 and not by the King or the Queen or the House of Commons or the House of Lords. In September of 1926, Russell Rogers Smith of the Native Sons of Canada, a movement aimed at fostering national spirit, creating Canadian nationality, adopting a Canadian flag, and having more autonomy, presented a resolution to the Prime Minister, Mackenzie King. One main request of that resolution was the necessity of elevating Canada constitutionally to the status of a sovereign nation, and to confer on Canada an equality of status with Great Britain. It requested an equal and independent sovereignty under the Crown of Canada. Another request was that Great Britain should not be allowed to make Canada pay for any claims that may arise out of Great Britain's defense actions. Another important request was that all natural resources of Canada belong to the people of Canada and not Great Britain. The resolution further requested that the roles and authority of the Governor-General be fundamentally changed for the benefit of Canada. As we will see, it was the work of Russell Rogers Smith that would have paved the path to real freedom. In October of 1926, at the Imperial Conference in London, led by Lord Arthur J. Balfour, Mackenzie King, and representatives of the other dominions of Great Britain met to discuss and determine the status between Great Britain and the dominions of Canada, South Africa, Australia, New Zealand, and the Irish Free State. The report concluded that the dominions are autonomous communities within the British Empire, equal in status, in no way subordinate one to another in any aspect of their domestic or external affairs, though united by a common allegiance to the Crown, and freely associated as members of the British Commonwealth of Nations. This was scheduled to be made law with the enactment of the Statute of Westminster on December 11, 1931. Prior to the enactment of the Statute of Westminster, the Government of Canada was composed of a Governor-General and a select committee of the Imperial Privy Council, one of which headed the Supreme Court of Canada. Any member of the Imperial Privy Council was a member of the Government of Canada. the House of Commons, the Senate of Canada, the Privy Council for Canada, which was appointed by the Governor-General, and the Lieutenant Governors of the provinces were to aid and advise the Governor-General in the government. The Governor-General was the sole government. Neither the Legislative Assembly nor the House of Commons were responsible to the Canadian people. They were responsible to the Governor-General only. Each Lieutenant Governor, appointed by the Governor-General, was also a corporation sole, acting as the representative of the Governor-General, and not as a representative of elected representatives or the people. As we will see, the Statute of Westminster is the most important document in the history of the landmass known as Canada. We will only look at the three key sections of the Statute of Westminster that apply to the Dominion of Canada. These are: Section 2 removed colonial law from the Dominion of Canada. Recall, the Dominion of Canada was defined as a colony of Great Britain. No law made by the Parliament of a Dominion is void just because it may not be in accordance with British law. This section does not apply to Australia because Australia had a so-called constitution in 1901 and was not a Dominion in 1931. Let's look at Section 11 before looking at Section 7. Section 11 of the Statute of Westminster severed the connection between the Dominion and a colony of Great Britain. What does this mean? The key word is notwithstanding. It means Section 11 overrides the Interpretation Act of 1889, which defined the term colony. The provinces were not joined as one colony of Great Britain any longer, and each province was also not a colony of Great Britain any longer. Who owned the land now? The people of each province naturally took ownership of the land. This also removed the Governor-General because the Crown and Chancery lost the allodial title to the land. There is no intermediate status between that of a colony and that of a sovereign state. No confederation happened because the provinces had never been sovereign states. Section 11 finally raised each province of Canada from the position of a colony to that of a sovereign state. Section 7 is misleading in how it deals with the applicability of this statute to Canada. Subsection 1 attempts to exclude the BNA Act from this statute. However, the BNA Act was only a statute, a guide of the Imperial Parliament to aid the Governor-General. It could only be effective if there is a duly appointed Governor-General. See Section 12 of the BNA Act, 1867. Since the Crown and Chancery, who appoints the Governor-General, gave up allodial title to the land, thanks to Section 11, there can be no more Governor-General. The result is, this subsection is redundant. Subsection 2 clarifies that Section 2 of the statute removing colonial law also applies to any of the provinces. This makes each province a sovereign state, nation, or country, because confederation never happened. Only sovereign states can join into a confederation, and the provinces were not sovereign until the Statute of Westminster was passed. Subsection 3 clarifies that the provinces can only act within their boundaries and cannot impose laws on any other province. But what is the Parliament of Canada now? Is Canada defined? In summary, Section 2 removed colonial law from the Dominion of Canada as it was a colony of Great Britain. Section 7 removed colonial law from each province. Section 11 removed the status of colony, which immediately ended the Dominion of Canada. It also immediately removed the Governor-General. There is no intermediate status between that of a colony and that of a sovereign state. Sovereignty and the ownership of land go hand in hand. No confederation happened because the provinces had never been sovereign states. Each province of Canada was now for the first time a sovereign state. This status has not changed since December 11, 1931. No province has held a constitutional convention. No province has seated a de jure, lawful government. Extremely important. Every politician, every governor general, every prime minister, every law, every act, everything has been illegitimate since December 11th, 1931. Anything that was passed after this date is not applicable to the people of each province. Has freedom been hiding in plain sight for over 90 years? What happened after the Statute of Westminster was passed? Did the people in each province hold constitutional conventions and seat a de jure government? Sadly, no. Russell Rogers Smith said in the 1940s. What does the future hold? Is Canada to become an armed camp, each at the other's throat? Or can we unite to create a federal union, mutually adopting a constitution? It is very likely that many people did not comprehend at the time what the Statute of Westminster had actually achieved. The Great Depression also impacted many people who were desperately looking for help. In addition, it is likely that many of the politicians at the time did also not comprehend what the passing of the Statute of Westminster really meant. It seems that those who did know simply continued as if nothing had happened. After all, there was a lot to lose. Recall Section 109 of the BNA Act. In 1936, the Parliament of Canada attempted to revise the Statute of Westminster. They wanted to revise Section 7 of the statute to give the Parliament of Canada the power to enact a federal constitution and to continue the BNA Act until such constitution was in place. Did the Parliament have this power? Was the Parliament legitimate? Parliament also tried to amend the BNA Act. However, the BNA Act cannot be implemented without a Governor General. The Governor General used to be appointed by the Crown and Chancery, but the Crown and Chancery lost the title to the land. From the official website of the Governor General of Canada. Until 1931, Canada's Governor General was chosen by the Sovereign. This changed when the Canadian government began to make recommendations for the position. Who was the Sovereign? How were Governors General appointed? What changed in 1931? Who gave the Canadian government the authority to appoint the Governor General? Did they simply assume this authority? Could they issue letters patent? In 1945, Walter Cool, a member of Parliament from Alberta, addressed the House of Commons and presented a detailed speech about the constitutional problems. He clearly outlined the current status and the actions that should be taken. However, no action was taken. In 1947, Prime Minister Mackenzie King issued letters patent, appointing a Governor General. These letters patent were signed only by Mackenzie King. To this day, only the Lord High Commissioner of Great Britain, the Crown and Chancery, can issue letters patent. Nobody else has the power or authority to issue letters patent. The last ones that were issued are dated March 23, 1931. In 1948, the Income Tax Act was implemented by an illegitimate Parliament of Canada and signed by an illegitimate Governor General, Harold Alexander of Tunis. In 1952, the Royal Style and Titles Act was enacted by an illegitimate Parliament of Canada, in which the Parliament of Canada assented that Elizabeth II can proclaim herself to be the Queen in right of Canada.
The moment the Queen puts her signature on this document, it becomes law. It will be witnessed later. The Constitution is now home. A fanfare in the background, as you can hear.
In 1976, Walter Cool, a member of Parliament from Alberta, wrote a letter to René Lévesque, Premier-elect of Quebec, explaining that Quebec does not need to seek a formal separation because the province has been completely independent and sovereign since December 11th, 1931, just like every other province. How can you be divorced when you have never been married? In 1982, Pierre Elliott Trudeau initiated the grand deception that is called the Constitution Act of Canada, also known as the Charter of Rights and Freedoms. An illusion, as we will see, which many people strongly believe to be factual truth. Trudeau is said to have patriated, which means to transfer legislation to an autonomous country from its previous mother country, the defunct and meaningless BNA Act 1867 to Canada. Why did he only bring a photocopy? Why does the original BNA Act 1867 still reside in the parliamentary archives of Great Britain? Trudeau urged all provinces to ratify, which means to give formal consent to make something official, the document, so that Canadians could enjoy their new constitution as soon as possible. Did all the provinces sign? Was it ever ratified? Section 58 of the Canada Act, 1982, states that this act would only come into force by proclamation issued by the Queen or the Governor-General, and only if the conditions of Section 59 were met. Section 59 is equally important to comprehend. Subsection 1, paragraph 23, 1. A shall come into force in respect of Quebec on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Subsection 2. A proclamation under subsection 1 shall be issued only where authorized by the Legislative Assembly or Government of Quebec. Subsection 3. This section may be repealed on the day paragraph 23, 1. A comes into force in respect of Quebec and this act amended and renumbered consequentially upon the repeal of this section by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. The key phrase here is in respect of Quebec. Section 23. Minority language educational rights. Citizens of Canada, whose first language learned and still understood is that of the English or French linguistic minority population, have the right to have their children receive primary and secondary school instruction in that language in that province. Recall Section 59, subsection 3, in respect of Quebec. This section may be repealed on the day paragraph 23, 1. A comes into force in respect of Quebec and this act amended and renumbered consequentially upon the repeal of this section by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. This means that only Quebec would lose their educational right in the French language. What were the steps to ratify and enact the Canada Act, 1982? 1. All provinces would need to sign Schedule B of the Act, the Charter of Rights and Freedoms. 2. Quebec would need to authorize a proclamation to enact Section 23, 1A of the Act. 3. Section 23, 1A would be enacted through a proclamation. 4. Section 59, 3 would be enacted through a proclamation to repeal Section 59 and renumber the Act. 5. Section 58 would be enacted through a proclamation to pass the Act. A total of 3 proclamations were needed to pass the Act. Which of these steps have been completed? None. But what about the proclamation from 1982? From the Royal Proclamation, 1982. Now know you that we, by and with the advice our Privy Council for Canada, do by this our proclamation declare that the Constitution Act 1982 shall, subject to Section 59 thereof, come into force. Recall, subject to Section 59 means 2 proclamations must be made before the final proclamation to pass the Act, Section 58, could be made. This Royal Proclamation, 1982, is only a proclamation stating that there will be a proclamation in the future. Nothing was passed. Nothing was enacted. There is no Constitution. There is no Charter of Rights and Freedoms. The Royal Proclamation 1983 had nothing to do with the passing of the Canada Act 1982. This act simply converted the status of Aboriginal people from sovereigns to persons. Even the 1987 Meech Lake Accord and the 1992 Charlottetown Accord failed to enact the Canada Act 1982, also known as the Constitution Act 1982. Reminder, everything since December 11th, 1931 has been illegitimate, null and void. Since the fraud has obviously continued, why would Quebec not speak up and call it out? Maybe the over $12 billion in equalization payments that Quebec has received on average each year has played a role. Let's take a look at the Charter of Rights and Freedoms. Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out and it's subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. This gives the government the option to ignore the Charter, and it is why the courts often side with the government. Section 7. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. What is a person? Section 32. This charter applies to the Parliament and Government of Canada, and to the legislature and government of each province. Does the charter apply to the living men and women, or only to persons? A charter is a reservation of a ship, or a written grant, by which a corporation is founded and its rights and privileges are defined. A ship needs to be chartered to land it and reflag it. A person is a legal fiction. A corporation is also a legal fiction, but not a person. The charter was meant to create a ship at sea, which was intended to bring maritime law onto the land. Through persons, the living men and women would be brought under maritime law jurisdiction. This is why all provinces needed to sign the charter. A charter differs from a constitution in this that the former is granted by a foreign government, while the latter is established by the people themselves. There is no lawfully established independent country called Canada. There is a geographical area that is comprised of sovereign nations, also known as provinces. How exactly is Canada defined in the Interpretations Act 1985? Canada includes the internal waters of Canada and the territorial sea of Canada. Canadian waters includes the territorial sea of Canada and the internal waters of Canada. Internal waters means the internal waters of Canada and includes the airspace above and the bed and subsoil below those waters. Territorial sea means the territorial sea of Canada and includes the airspace above and the seabed and subsoil below that sea. The land is not included anywhere. Why? Because they lost access to the land when the Dominion ended with the Statute of Westminster, when the land was naturally returned to the people. Through the person, the all-caps name on all forms, IDs, licenses, passports, birth certificates, etc., you have submitted yourself to operate within maritime law. You have only those privileges that the corporation grants to you. Those do not include unalienable rights. What is the solution? How do we get out of this? Do we want to get out of this? Educate yourself. Learn these facts. Break the patterns and the indoctrination, like celebrating Canada Day and waving the Canadian flag. Educate your children because they are the ones building the future. Using the Socratic method to break through the brainwashing, asking simple questions instead of presenting facts, educate your family, friends, and neighbors. Offer help, kindness, and patience to those that have awoken from the deep sleep and are desperately looking for answers and support. When the people in each sovereign province are ready, a constitutional convention will be held to elect delegates and agree on a provincial constitution, accepted by a majority of the people, after which a de jure, lawful government is seated. This will all need to be done without corporate interference of any kind, for example, bar-carded attorneys. Only after each province has been properly established with a constitution and a de jure government, all provinces can then, if they desire to do so, hold a convention to discuss a federation of the provinces. We have been living under communist tyranny as slaves within a corrupt, corporate, yet illegitimate system based on maritime law for decades. Some people like it, but most don't. Waving and displaying the Canadian flag is not a symbol of freedom and free spirit, because it is the symbol and trademark of an evil corporation. When you wave this flag, you are submitting yourself to the color of laws of the corporation. For many years, people did not want to hear the truth. The truth and its speakers were ridiculed and silenced. Lately, though, more and more people are suffering at the hand of communism, and they do not like it. They see that something is deeply wrong. Since the people on the landmass known as Canada have been indoctrinated for decades and conditioned to be obedient slaves of the system, many may have to suffer immensely to be broken enough to accept the truth and to have the will to change. If recent worldwide events are any indication, then nothing can stop what is coming.
You never change things by fighting the existing reality. To change something, build a new model that makes the existing model obsolete.